I own a house in an area that the government thinks could be improved, and I have a perfectly nice house and it's a clean house and there's nothing particularly wrong with the area, but it could be better, it could be more vibrant, there could be more dynamic businesses, is that enough for the government to take the house?
Under New York State constitutional law, yes, it is.
Developer Bruce Ratner and his company, Forest City Ratner, are proposing constructing 16 skyscrapers and a $950 million sports arena in the Prospect Heights neighborhood of Brooklyn, to be known as Atlantic Yards. Besides relying heavily on taxpayer subsidies, the developer is requesting that the government take property for the project using its power of eminent domain. Eminent domain is the seizing of property by the government for public use. It can be used for hospitals, roads, parks, and government-operated public housing. Eminent domain abuse occurs when private developers, such as Forest City Ratner, persuade the government to take property for themselves under the guise of public benefit. There is an epidemic of eminent domain abuse in New York and around the country. The ESDC, which is also known by its original name, the UDC, is a governmental agency now involved in the long-standing legal fight with tenants, home, and business owners in the proposed project area who have been under the threat of eminent domain for over 5 years. Ratner's cronies in the Empire State Development Corporation are attempting to use outdated slum clearance regulations to claim 22 acres of valuable real estate for Atlantic Yards and evict people from their homes, claiming the neighborhood is blighted. A broad-based coalition of community groups, with support from many local elected officials, has formed to advocate against this eminent domain abuse. Calling themselves Develop Don't Destroy Brooklyn, or DDDB, this umbrella organization has led the opposition in defending the neighborhood and advocating an alternative development known as the Unity Plan, which involves local union labor and no use of eminent domain. Their David and Goliath struggle has made it to the New York State Court of Appeals, and on this day, members of DDDB, including several of the plaintiffs, head from Brooklyn to Albany for the oral arguments in this landmark case.
Welcome to the Eminent Domain Albany or Bust bus trip.
You know, it's so interesting that this bus is named the Omega Express. Omega means the end in the Bible. And so, you know, we began 6 years ago, and here we are almost at the end. And these individuals are getting on the Omega Express. I don't think we're at the end, but we're close to it. But I think, you know, really, it's really critically important that Prospect Heights and Park Slope and Fort Greene and Clinton Hill, that they go to the court, and that they breathe life into the papers that the court will review, and that they give a face to the plight that we are facing here in Prospect Heights, and that they recognize this really is a hostile takeover, and that we will not allow it, and that we love this community, and that's why we're going to sacrifice our day to go to Albany. They carry with them all of the residents of Fort Greene, Clinton Hill, and Prospect Heights who basically want to develop our community but not destroy it.
Things don't change until the people rise up, right? And so I salute you and I thank you for rising and continuing to rise. And even in the midst of those naysayers, you have continued to demonstrate that you will not only rise, but you will stand strong. So enjoy the trip, safe travels, and we'll see you when you get back.
The Court of Appeals is the highest court in New York State. They will be deciding basically the same issue that was decided in the federal court in terms of the interpretation of a particular provision of the law, but this is the New York State Constitution, and New York has the right to interpret their constitution in any way they want. Matt Brinkerhoff is our attorney who will be arguing that public use did not intend public benefit. We will be using the history of constitutional interpretation all the way back to the 1800s to say that the Constitution should be strictly construed rather than the looser interpretation which would allow them to take the land for Atlantic Yards. Article 18 of the Constitution, which says that public funding cannot be used unless there is housing for certain income residents of New York State. That has never been interpreted. And then there will be a small part of the argument that says that the ESDC failed to weigh private benefit to Ratner against the public benefit, and had they done so, that the private benefit would be so great that it completely outweighs any minor public benefit that we're getting from this project.
This is not 1936. We do not live in old law tenements. Our neighborhood is not unsanitary or blighted. And other courts have been beholden to the standard that we are. This one is not. So, no, I feel very encouraged about it.
It's a great day for a victory.
I can smell it.
I smell victory.
Yeah,
Yeah,
I smell
victory in the air.
Smell it too.
This is the only time we've ever been in a court, any court, that has the wherewithal to overturn itself when it comes to interpreting the state constitution. And this is an opportunity for the court to reverse this.
My name is Claudia Massa. I'm from downtown Brooklyn, and I'm here today to protest the Atlantic Yards project to stop the abuse of eminent domain in Brooklyn and the entire city, state, and country. This project is about profit of a billionaire. It's not about what's necessary for the community, and we are here together to say we are just beginning the fight. We're not stopping, and we are going to win.
Well, the bells are tolling for the Empire State Development Corporation.
How much I love them, right? Almost as much as the Empire State.
Thank you, everyone, for coming from all around the state, up from the city and Brooklyn and elsewhere. And thank you, everyone standing here, for making the trip up. It's fantastic, and it shows how much interest there is in today's extremely important case, both for the state of New York and the Atlantic Yards project in Brooklyn. My name is Daniel Goldstein. I am the lead plaintiff on the case. There are 9 plaintiffs on the case. There are homeowners, there are residential tenants, there are business owners and business tenants, which pretty much covers all the types of ownership we have available to us in New York State, which means that the abuse of eminent domain pretty much affects everyone in New York State. One of the other plaintiffs is David Sheets on my left, who lives pretty much right where the arena would go, as do I. Another plaintiff with us today is Henry Weinstein. Everyone else you see here, for the most part, pretty much everyone, are residents of Brooklyn, New York, and they have been involved in the 6-year-long fight against the Atlantic Yards project, its abuse of eminent domain, and all of its other abuses. As you know, the case that will be argued at 2 o'clock today is about the issue of public use and eminent domain in New York State, and you will see what will be a very compelling argument about important issues about what New York State's Constitution means when it talks about public use justifying the seizure of people's properties. There will also be a discussion, I'm sure, of what blight means in the year 2009 in New York State versus what it has meant over a long part of New York State's history. Those will be the big issues discussed today, along with what is economic development versus public use. Is economic development a public use? Those are the overarching issues that will be discussed today. We expect to win this lawsuit. We know that we are right on the law, and we know that when we do win, it will be a huge victory, not just for us in Brooklyn, not just for the homeowners, but everyone who cares about justice and adherence to the law in New York State. We're going to hear first from our state senator, Belmonte Montgomery, who represents the 18th Senate District, which includes the entirety of the proposed Atlantic Yards project site. She has been a leading opponent of both the abuse of eminent domain and this Atlantic Yards project from 2003. And we really appreciate that she's here with us today and all that she has done over these past 6 years. Yes. Senator Montgomery.
Thank you. I want to thank my constituents for coming up here today. This is an extremely important case that is before the Court of Appeals, and we think that this is the only right thing to do. We have a situation where the state of New York is participating in actually abusing the law, eminent domain, because this project is not a public use, essentially, to throw people out, including this baby, who is the baby of Dan Goldstein here and his wife. They will be removed for the purpose of having a stadium, a ball stadium, which will be I think the 4th ball stadium in the city of New York. There is no need for that kind of facility, and furthermore, it advances the economic interest of a developer. It is not in the interest of the people in the city of New York. This really is the worst possible example of how government can interfere with the quality of life of people in our state. We must fix this. But today we hope that and we anticipate that the court will rule on the side of the people of the state of New York. So we thank you for coming up here, and these people are my constituents, and I am indeed angry that we have to fight this kind of fight in order for people to keep their homes. So I thank you, and we look forward to a decision on behalf of the people.
Thank you.
Thank you, Senator Montgomery. Besides David and Henry, we're also going to hear from Christina Walsh from the Institute for Justice, who has come up here from DC for this. Institute for Justice is perhaps most well known for the Kelo versus the City of New London case, which they litigated back in with the ruling back in 2005 in front of the U.S. Supreme Court. A terrible split 5-4 decision, which New York State today and this court needs to say that terrible decision does not apply in this state. Okay. We're going to hear from David Sheets, who, as I said, is a tenant who lives on Dean Street in Brooklyn, which is precisely where the arena that the senator discussed would be. David, along with myself and other plaintiffs, have been dealing with this cloud of eminent domain hanging over our heads for the past 6 years. It's something that angers us a great deal, and it's something that we've had to really grapple with for a long time. So we're very pleased that we're going to have a very civilized argument about it today in the courthouse. David.
I would also like to say that I'm very glad that everyone is here. This is a matter of principle. I am a renter. I am not a homeowner. I can go find another apartment. That is not the point. What is happening is unethical. It has been deceitful. People have been lied to. Segments of the community have been pitted against other segments of the community where that had not been the case before. It's shameful. This is certainly not a public benefit. People have been fighting each other for years and have been lied to. That is not a public benefit. People hide behind the argument that, well, takings clauses are worded that the government can step in and take because property owners are just compensated. It's kind of hard to believe that in a city of 8.5 million people, where more than 3/4 of the population rents, it somehow falls through the cracks and nobody thinks about the fact that we don't own anything. We shouldn't have to live like this. We didn't do anything to deserve this. So it's not a matter of not in my backyard. It's a matter of not in my bathroom, and my kitchen, and my living room. We live there. Those are our homes. Living in my neighborhood was like living in a small town. People had lived there for decades. And families that had lived upstairs, downstairs, right across the hall from each other, they had no choice but to move miles away, disperse, anywhere they could afford to relocate. The whole thing, and for a basketball arena, it's shameful. Thank you.
Thank you, David. We're now going to hear from Henry Weinstein, who, as I said before, is a commercial property owner. He owns an office building. As the rest of us, other types of owners who are forgotten, other types of victims of eminent domain abuse, besides homeowners, besides tenants, besides rent-stabilized tenants, are business owners who usually are preyed upon in particular, and this issue of just compensation, which is not what we're here about today, they get the short end of the stick almost all of the time, as everyone else does, but even a shorter end. So Henry's been fighting very hard in numerous ways with all of us for the past 6 years, and now we'll hear from Henry Weinstein.
Thank you. Thank you, everyone, for showing up today. This is a very important issue, and I guess I'm going to keep my statement short. I can't really understand why my government is allowing a private developer to seize my property, and why the Empire State Development Corporation has acted as a tool of the developer. Thank you.
Thank you, Henry. We're now going to hear from Christina Walsh, who is the Director of Activism and Coalitions for the Institute for Justice, which fights eminent domain abuse all across this country. And just recently, last week, issued a study that pretty much damned New York State as perhaps the biggest abuser, if not the biggest abuser of eminent domain, with the worst process of using eminent domain in the entire country, and that our legislature has not acted, which is why this hearing today, this argument today, is so important. Christina, thank you.
We are here today to vindicate the rights of every New Yorker to keep what they have worked so hard to own and what is rightfully theirs. Across this country, legislatures and courts are rejecting the Kelo rationale, that wildly unpopular decision that states that private property, perfectly fine property, can be seized and be replaced with something bigger and newer just because that new use might generate more tax dollars and more jobs. And while this rationale is being rejected across the country, New York is still behind the times. With 6 other states, New York has still neglected to pass reform, which has enabled tax-hungry governments and land-hungry developers to seize perfectly fine properties for private development just to line those rich developers' pockets. And that's exactly what's happening here today. A rich, politically connected developer and his tax-hungry government friend is going into Brooklyn and trying to take what isn't theirs simply to generate more private profit for himself. It is the court's duty today to review these abusive takings and determine whether they constitute a public use, which, as we discuss in the Institute for Justice's brief, they certainly are not. Every single state Supreme Court that has addressed the public use question in the wake of Kelo has rejected Kelo and is sided with property owners. And that's what we are asking the court to do today. We represented Suzette Kelo before the Supreme Court in 2005, and as we all know, she lost her property, and that was an awful decision. And 4 years later, what do we have to show for it? The developer balked. They lost their homes. And Fort Trumbull in New London is now a vacant wasteland overrun with weeds and home to nothing more but feral cats. And New London is now a black eye on this country for property rights, and we are not going to let that happen to New York here today. Thank you.
Thank you, Christina. I should mention, Christina mentioned it, but to clarify, Institute for Justice is one of the friend of the court amicus briefs on this case on the behalf of these plaintiffs, and we thank them for that. Everyone should remember that this really is an issue of the people against an abusive government. It's not a right or left or center issue. It is this issue that people across the political spectrum, the people, agree on. Nearly 90% in most polling, people agreed that the Kelo decision was a terrible decision. So this is not about political party or political point of view. This is about what is abusive, what's right, and what's wrong. And when a government is out of control and partnering with a private developer or any developer to take people's properties, to steal people's properties, to benefit that developer, and that is the purpose of these takings, then that is wrong, and the people understand that. What is clear about taking these 22 acres of prime real estate in Brooklyn is that the entity that will benefit for sure, is Forest City Ratner. That is the only certainty. Forest City Ratner will get 22 acres of great real estate by stealing people's property with the permission of New York State's Empire State Development Corporation. All the rest of it about public benefit that we've heard from the developer, that we've heard from New York State, is nonsense, is speculation, is happy talk, is the unknown. And if we look at what happened in New London, Fort Trumbull, that is clear. It is always unknown what the public will get. It is always misleading what the public will get. But what is a certainty is that Forest City Ratner will get 22 acres for a song by stealing people's properties. We know that what's gone on is wrong, is corrupt, is unconstitutional under New York State's Constitution, and that we are very confident that this court will rule for us.
Good afternoon. Matter of Goldstein versus New York State Urban Development Corporation.
Have you gerrymandered this area to fit what the developer wanted to build on, rather than taking an area of real blight? Suppose I'm a developer and I want to develop on an area which is half blighted and half not. Can I buy the property as much of it I can, hoping to condemn the rest. I go to the government and I say, I want you to condemn this, and they can condemn the whole thing, even though half of it isn't blighted, even if the area is one that the developer put together.
It is not primarily low-income housing. There's a great deal of public subsidy in terms of this project. How do you get around Article 18, Section 6?
Wasn't this originally seen as a community development project until the lawyers told somebody you've got to find blight or you can't condemn the land?
Absolutely not. There is nothing whatsoever in the record about that. No,
obviously there's nothing about what the lawyers said, but where does the word blight appear before? At the time this thing was announced and people were holding press conferences, where does the word blight appear?
They're saying that any time that your home or your business is not built out to the maximum degree allowable, it's subject to being declared blighted. And under this court's rulings in Yonkers, which were informed by Supreme Court precedent, it means that it can be taken and given to a preferred private developer so that they can generate more tax revenue, at least in theory.
It is certain that there will be no economic benefit from the arena. So, New York City has already invested a couple of $100 million in the project. Part of that money was for the developer to purchase properties so that we have, in fact, paid taxpayers' dollars to assist this developer in fact, attempting to create blight in the area. There is no blight there. It is an area that is surrounded by some of the most valuable properties in the state of New York, and this indeed will create a huge problem in that community, in those communities. Traffic has not been addressed. We already have a traffic problem there. There is no resolution to that, not even proposed by the city. The state has invested $100 million in it. The developer has received the property, part of that property, for less than its value, particularly the rail yards owned by the MTA.
If I own a house in an area that the government thinks could be improved, and I have a perfectly nice house and it's a clean house and there's nothing particularly wrong with the area, but it could be better, it could be more vibrant, there could be more dynamic businesses, is that enough for the government to take the house?
This is not a constitutional use of eminent domain.
There are so many egregious acts involved with this particular project, and eminent domain is just absolutely the worst one.